Happy to be back. And I will acknowledge recording. So happy to be back speaking with you today. And by way of introduction, I've been with the Division of Local Services as an attorney for over 10 years. And prior to that, I spent 20 years as a city and town attorney from over 100 Massachusetts municipalities. So my letterhead might be in your desk drawer somewhere or files, but yeah, and I started off as an attorney in Watertown, beginning my career, and prior to coming to the DLS, I was city attorney in Somerville. So, with that, I want to first of all, you've got a substantive day plan. I'm happy to present the first one, and I'm going to go over. Next slide, please, Beth. A quick rundown on the topics of conversation, and so, yeah, that's it. So today we're going to talk about, I'm going to start talking about the role of the Division of Local Services in your roles as staff of the Treasurer's Office. Should also note that the attorneys at DLS provide an attorney of the day hotline. You send us an email, we'll get to it within a week, or mostly just within that day or days. So we provide a rapid response for cities and towns, and it's an intellectual challenge for us. And as well, we provide presentations to groups all over Massachusetts on handling local government issues. So I'm going to also do a municipal finance overview of the process. I'll speak to the duties and responsibilities of officers generally, and then we'll delve into the specific roles and responsibilities of the treasurer. We'll talk about some other issues if we have time as well. So, I will now introduce DLS. So there are the executive branch and 5 bureaus, and I spoke before about the Bureau of Municipal Finance Law. The director, the bureau chief, is Ken Woodland, and the 6 attorneys at DLS provide information, guidance. We do educational programs like this one on a host of municipal finance issues. So feel free to call us at any time. And then we've got the Bureau of Accounts. That's the bureau you guys are probably dealing with frequently. That bureau oversees the financial management of municipalities within the Commonwealth. And staff members of the BOA assist financial officers with state regulations, requirements, approve tax rates, certify compliance with Prop 2.5, and offer instruction on municipal accounting issues that may pop up. Next, I'll talk about the Bureau of Local Assessment. And I should point out that Deb Wagner is the Director of Accounts. And then moving to the Bureau of Local Assessment, Chris Wilcock is the Chief of the Bureau of Local Assessment. That bureau is responsible for regulation, oversight, training, and technical assistance to municipalities in the areas of real and personal property valuation and classification. Those guys work predominantly with assessors on, they also recertify a community's property values once every 5 years to ensure that they are full and fair market value compliant. And next, I'm going to talk about the Financial Management Resource Bureau. Zach Blake is the chief there. And the Financial Management Resource Bureau advises municipalities on opportunities to improve their financial management operations. And our project teams come in and help cities and towns on various policy directions. And we also, through that bureau, handle financial management reviews of cities and towns upon request. And we also have the Data Analytics and Resources Bureau, which is run by Kirsten Shearer. That's responsible for collecting, managing, and distributing data. We have a ton of data. These guys crunch it. They also maintain the division's website, provide user support and software development services for Gateway, and provide training and consulting services for local government. in collaboration with the other bureaus of local services. So with that, we have a website, and yeah, you can see there www.mass.gov/org/Division of Local Services. You can log on to that to make a request for an attorney service for us, and we'll be happy to help you there. So let's move on to the next portion of the slide. What is municipal finance? So municipal finance is a process by which money is raised, appropriated, collected, received, borrowed, protected, deposited, invested, accounted for, and expended, reported, and audited for the purposes of providing municipal services such as police, fire, and health protections, and education, and the like. So without municipal finance, without a budget, the good things that we do as city and town officials won't happen. Now, I should also note that I'm a city councilor on my free time in Watertown. So I, having worked in city and town halls before as an attorney, now as a councilor, I have a deep background in working with local governments as well. So the process of municipal finance is governed primarily by general laws. We have general laws, Chapter 39, Chapter 40, Chapter 41, Chapter 44, sections, chapters 58 through 61B, and then parts of Chapter 30B, the Uniform Procurement Act, Chapter 150E, the Collective Bargaining Act, and other general and special laws. So the authority to levy taxes can only be done by state law. Cities and towns can't raise their own taxes, but they can charge fees for services. So provisions for expenditure of municipal funds are conservative, intended to protect the public. Ordinarily, expenditures must be authorized by legislative appropriation. In some circumstances, the state legislature has authorized expenditures without local appropriation from certain receipts to be used for special purposes. So system of checks and balances is a warrant process for expenditures. So in order to pay our payrolls, our department head would sign off on warrants for payments of wages, and the town accountant or city auditor, depending on which location which level of government you're at, will review and check. And we'll talk about that a little bit further on. And there's general separation of spending and auditing. So anyone who serves as a town accountant or city auditor cannot likewise handle cash. So it's a check and balance system. And then limitations on spending authority, can't overspend your budget. Chapter 4431 states that you cannot enter into an appropriation unless there's a payment for that or payment source for that. So let's move on to the next slide. We'll talk about the who does what. And these are your colleagues and other city departments, city and town departments. So quick question, the legislative body appropriates, whether that be your town meeting or your city council or city council. So the city council, town meeting authorizes appropriations, can't spend unless they appropriate. And the chief executive officer oversees expenditures. So in cities, the chief executive officer would be a mayor or city manager, and towns, depending upon your how you're structured, generally a board of selectmen or select board, or a town manager if that person is given authority. So they oversee the expenditures. So legislative body authorizes spending, CEO handles expenditures and handles procurement and down the like to other roles in city and town government. So as I mentioned before, with respect to wages, department heads authorize spending. They send out a warrant, attesting that the information provided is true and accurate, that goods were actually received, services rendered, and that they authorize spending, and that goes to the town accountant for authorization. Town accountant approves, then the treasurer expends the funds. So some in towns only, FinCom advises and controls the reserve fund. Reserve fund is set aside for emergency purposes. FinCom also hopes to oversee the budget, depending on what role FinCom exists in your town. But on the city side, the city council has an appropriations committee or some kind of arm to take over that role. Council oversees the spending decisions of the oversees once the matter has been appropriated, make sure city councils and town councils and towns they provide oversight of expenditures as well. So with regard to assessors, Board of Assessors determines property values and they assess and commit taxes. So we have generalized chapter 5938, 5943, and a process for fair and full cash valuation of properties. Then they also, the assessors determine tax rates. So a rate is the amount per thousand authorized by the to meet a budget up until we've got a spending limitation. Proposition 2.5 caps the amount a town or city can levy taxes to a history of just adding 2.5% on top of last year's levy, plus new growth and let's see, and other factors as well. So move on to the collector. The collector collects taxes and other charges if authorized, pays the amounts collected to the treasurer, and provides other assistance with the treasurer. Oftentimes, the latest trend over the last 20 plus 30 years is to combine offices of treasurer and collector, since they handle a lot of the same functions. So talked before about the accountant. The accountant is in charge with monitoring expenditures. So I mentioned before, town accountants and city auditors perform the same tasks. So they maintain, examine, and inspect books of accounts. They approve bills and payrolls that aren't deemed to be fraudulent, unlawful, or excessive. And they prepare annual statements and reports of appropriations and expenditures, and they keep copies of all contracts. And town clerk, keeps records and certifies appropriations that are voted by town meeting, city council. They keep other municipal records, birth, death records, the like. And city clerk also keeps copies of contracts. So we're going to delve right into the roles of the treasurer. Like briefly, treasurer has custody, invests, makes payments, withholds, and handles a number of issues. We're just going to jump right into that now. So next slide, please. And we're going to talk about the role of the treasurer staff and treasurer's role in securing custody of funds, safekeeping of the public funds, investment opportunities and limitations, and the treasurer is the exclusive authority to pay bills that were properly authorized by the auditor or accountant. And treasurer can withhold revenues or withhold salaries, garnish wages, the like, or certain issues. And also the treasurer accounts for receipts and disbursements. So money comes in, money goes out. Treasurer keeps tabs on those records. Treasurer is also charged with, involved with the borrowing of short and long-term debt. You've got a borrowing issue for to build a new school through a debt exclusion, perhaps, and the treasurer's office deals with the folks issuing the bonds and other loan issues and miscellaneous. So we're just going to jump right into role. But first, we're going to talk about budgets. Next slide, please. So city and town budgets are an annual authorization of expenditures, providing all the duties that we as city and town officials do, providing education in schools, fire protection, police protection, and the like, everything, and including our own salaries and such. So the budget could involve both non-recurring and capital items. Capital items are the purchase of goods, so fire trucks, ambulances, and the like. And revenue sources for a budget include the largest source being taxes, both real property on your house, your business, and personal property taxes. Certain businesses pay personal property taxes for equipment used in providing their business. Local aid, you see local aid through highway funds called Chapter 90 funds. You've got education funds coming in, and generally most communities will have the property taxes and real property taxes dominating the amount, but there are some communities that where local aid is the higher number than property taxes. So we also have fees and charges. So before Proposition 2.5 limited the amount of taxes that could be levied. After that, it's thought that we should charge more for services. So you got fees for anything from, some towns have a trash collection fee, some have tons of fees for that for any purpose. Your marriage license fee, and other types, and charges that come up. Providing a service for copying records, for example, public records law sets a certain cost that a community can charge for that service. Then you got gifts and grants that you've got both federal grants, state grants that come in. You got gifts from great donors who want to do something good for a town, or foundations want to see a particular purpose. That's a source. And available funds, it's the amount that's available to be spent. And then we have fund accounting duties that come up through the treasurer's office. We're going to get a little into that as well. And let's do science. So now we're going to focus on the duties and responsibilities of the treasurer. So let's move on to that next slide. And the treasurer takes custody of municipal revenue under Chapter 41, Section 35, and Chapter 44, Section 53. So Chapter 44, Section 53 is important in the sense that all money received by any municipal officer or department, except as provided by special act, must be deposited in the general treasury. So oftentimes you see a department head saying, well, if my department wasn't here, this money wouldn't be coming in, it's going to my budget. Not necessarily. So that'll be a prime a statute in municipal finance. We'll talk about special funds along the way, but in general, all money is received by a department must be provided to the treasury. And the next slide, please. And let's say several statutes require the deposit, but little variation from the general rule of 4453 stating that all municipal funds must go into the treasury. Several statutes require the deposit of funds to separate accounts in the treasury as opposed to the general fund. So these include Chapter 40, Section 5B, stabilization funds, Chapter 41, Section 46, trust funds. And we spoke before about grants and gifts. There's a separate way of treating them under General Laws, Chapter 4453A. They can be spent by a department head in that sense, but it's only if they are so authorized or treated as a gift. And we'll get into off-duty work details that any employee, police, firefighter, custodian, working extra or a private event, there's a fund where those funds for the payment of those services is deposited. And we're actually going to talk about that further on. Then we have revolving funds, a number of revolving funds, such as Park and Recreation revolving funds. So in that sense, the Parks and Recreation Commission, they provide fees for services. So you're going to take a tennis lesson with a staff from the Recreation Department. You're going to pay for tennis lessons. Such monies can be put into a revolving fund. Those revolving funds can be used to pay for the part-time coaches and instructors for these programs. Then we also have a municipal scholarship fund where folks can make donations to a scholarship fund, and that's a separate example of those are held separately apart from the general treasury, as you know, most municipal receipts are. So let's move on to the next one and talk about timing of bonds. So bond requirements. So under General Laws, Chapter 41, Section 35, treasurer must obtain a bond annually in an amount not less than that amount set by the Commissioner of Revenue for the faithful performance of his or her duties. So the bond must be given within 10 days after the treasurer's election or appointment, or the office may be declared vacant. That's how important the bond is. The bond includes responsibility for trust funds and retirement funds in the treasurer's schedule. Right, let's move on to the next one. So big issue with the conservative treatment of municipal funds. The treasurer is the frontline person in charged with safeguarding municipal funds. And there are liabilities attached if a treasurer fails to comply with state statutes and duties. The first case of Mansfield versus Hannaford, decided in 1925, but it's still valid law. The holding in that case was that treasurer was personally liable on his bond in an action of contract to recover town funds in his custody, which were stolen without negligence on the treasurer's part, even though the funds were kept in the town's safe and vault. So high standard. Case of Hancock versus town of Hancock versus Hazard. That case, the treasurer limited the amount, the treasurer was limited to the amount that he or she could, well, the holding was that a treasurer is limited to the amount that he or she can deposit in certain banks and restricted to banks in which he or she is not an employee or officer. So you can see the conflict of interest there. If you've got, you're a director of a bank, you're treasurer, you put monies in that bank, you know, there's certain prohibitions on that by statute as well. So let's move on down. So public funds on deposit, we're going to, as we stated, we talked about the Hancock versus Hazard. Under General Laws, Chapter 44, Section 55, there are limits on deposits. We talked about the conflict of interest and the issue with you know, certain investments that are authorized. You know, the MMDT is essentially bonds, notes, and then money market funds or town treasurers can invest in such. And so let's move on. Next slide, please. So treasurer's liability, we talked about that before. The treasurer or other town officer depositing funds using due care and acting lawfully and in good faith is not liable for monies deposited in certain banks, which later close up and liquidate. So the institution goes bankrupt. That's an exception to the general rule that treasurers are liable or, you know, are held to a high standard to prevent, guard municipal funds. So Chapter 44, Section 55B talks about the duties of treasurers to invest with the highest possible rate of interest, but at the same time maintain balance of safety of the funds and the liquidity and yield. So it's treasurer is required to invest trust funds and under section 54 and public funds. So treasurer is required to invest funds which are not required to be kept liquid at the highest possible rate. And there's reference to a legal list. The legal list under chapter 44, section 54 describes the appropriate sources or appropriate investments that public trust funds may be invested in, and generally conservative. And your folks later on in the training will talk about those sources as well. But generally banks that are insured by the FDIC, credit unions are not insured by the FDIC, so those are not a proper investment. And there's a whole bit of a laundry list about where they can be invested. And yeah, it's generally to keep safeguard towns, city funds, in case you can't have a charter saying, hey, I got a good stock tip. Let's put $10,000 of town money into that stock tip. Yeah, can't do that. That's must comply with the legal list. So let's talk about the roles of the treasurer and paying bills and claims. So under only is properly authorized by proper town officers. So under general laws, chapter 41, section 41, the treasurer may not pay a salary or compensation to a municipal officer without sworn approval of the appointing officer, head of the department, employing the person, or designee of a department head, commission, committee, board of trustees, or legislative body. And the department head issues a warrant for payment of wages and receipt of any goods that come in. The department head sends a warrant that's reviewed by the town accountant, city auditor, then the treasurer makes payment. So it's safeguarding along the way. So let's go down. Next slide, please. Well, approval of the bills, as I jumped the gun a little bit there. So the city auditor or town accountant, board of selectmen review and approve bills. So town accountant approves all bills, drafts, orders, and payrolls before the treasurer may pay them and must draw a warrant for such payment. If the town auditor, town accountant, or city auditor finds the expenses sought to be paid either fraudulent, unlawful, or excessive, the treasurer may not pay the claim or bill. And so the town accountant city auditor has to provide a written statement to the treasurer with the reasons why that warrant is improper, either fraudulent, unlawful, or excessive. There are certain statutes, for example, that prohibit the purchase of alcohol using town funds. So if a bill came from a department head who hosted a retirement party for a departing employee, there's a large bar tab that cannot be paid by using town funds. That would be something that would be flagged as unlawful since there's no authority to spend that. And let's see, so little written statement must be filed, and you've got all sorts of cases where Mayor Chelsea versus Treasurer of Chelsea, you've got disputes over proper payment, but the same requirement is that the auditor or accountant must approve bills, and they will not be paid without, if a statement is filed that such bills are unlawful. Let's move on to slide 18.
If it's so excessive,
So approval of bills in towns, and this is,
this is new.
let's see, 4156. We talked about the role of the town accountant, the 3 tests fraudulent, unlawful,
Some of them
excessive.
probably is
Spoke
fraudulent.
about that, and also the
And I have to let the treasurer
need
know
of
why
the
he
town
denied.
accountant or auditor to provide written notice of the denial to the treasurer. And with that written notice, treasurer cannot pay the funds. So next slide, please. So we've got a case of Treasurer of Raleigh versus the town of Raleigh. And we'll see that in that case, the treasurer had, the holding was that the treasurer had no standing to raise issue of legality of payment of town officials for hourly wages in contravention of a fixed annual compensation statute. So if the payrolls were authorized by the Board of Selectmen and town accountant, who alone were given authority to disallow payments, fraudulent, unlawful, or excessive, nor would the treasurer be liable for paying wages in excess of appropriations under General Laws, Chapter 41, Section 31, because the town accountant alone is given the authority to monitor expenses and appropriations. So another important point, General Laws, Chapter 41, Section 31, there must be an appropriation source in order for payment to be made. So that's another hallmark of municipal finance. So let's talk about the contents of the payroll. So under Chapter 41, Section 42, payrolls, bills, and accounts must contain the full name of each employee, the official office of that employee, the title, position, salary, wages, and other compensation, and dates of employment. Next, please. So next statute, Chapter 149, 148, hugely important for city and town officials to make sure they comply with. So under Chapter 149, Section 148, wages, every public officer whose duty is to pay money, approve, audit, and verify payrolls or perform other acts relative to payment of public employees. Let's see, must make payment, must ensure that payment is made to employees, weekly or bi-weekly within 6 or 7 days of the days worked, but it could be bi-monthly or semi-monthly or monthly. But city employees and town employees must be paid in this way unless the employee agrees otherwise. If payment is not made beyond that amount of time, then very important, the town or city is liable for triple damages and attorney's fees for employees whose wages were paid beyond that time. So it's a very.
It's gonna go to the next slide.
Hello. So. Okay, so.
Go to the next slide.
Hey, excuse me. Could you mute yourself, please? So if you can back up there, please, back up on that slide, please.
Yeah.
So
It's still, it can't
could
be.
someone who's speaking, please mute yourself?
Yeah, that's it. Oh, yeah, we did that.
Okay, well, I don't know how to handle that, but payment of salary is very important. Triple damages or attorney's fees if late payments are made. So let's move on. Different variation with regard to off-duty work details. Let's move on to that one. Under General Laws, Chapter 44, Section 53C, there is a revolving account for off-duty employees who are working details not related to their employment. For example, if a custodian is working a detail for a private party at a school cafeteria off hours, then payments made by that private party for that custodian services are deposited into the off-duty work detail fund. And under that scenario, and also I think a police officer is working details on construction sites. So any payment rendered for these services by a private party. Could we have slide 21, please? Thank you. So any payments must be made within 10 days. Next slide, please. Yeah, thank you. So any detail fund, the wages must be paid to the city of town employee within 10 days after the payment was received by that private party. So that's different from the general, the statute I talked about before, chapter 149, 148. And I should note that the Opto-D Work Detail Fund allows for administrative fee up to 10% of the wages worked in order to pay for the administrative details that come with paying out these checks as well. Next slide, please. So we're going to talk more about more treasurer duties here. So under let's see, under chapter 60, section 53, if taxes aren't paid within 14 days of a demand, the collector may take the taxpayer's land, and collector makes tax takings under general laws chapter 54. And the collector files an instrument taking and certifies that to the treasurer, and along with the subsequent, once the initial taking is made, then a tax title account is created and subsequent years of taxes can be put into that tax title account. So So the town treasurer and institutes foreclosure proceedings under section 62 and 65. We'll get into that. But then treasurer has custody of instruments of taking. So the collector starts the process, but treasurer has custody of instruments of taking. We'll move on to the next one, please. The treasurer initiates foreclosure proceedings as soon as authorized by section 62 and 65. In that case, we've already have the collectors turning over to the custody of the treasurer deeds and instruments of taking. The treasurer maintains a separate account. The town treasurer institutes foreclosure proceedings. That's a process in the land court. So let's see. And then we're going to talk about two processes of foreclosure proceedings. The first one is land court, and the second one is the land at low value process. So skip over the next slide. We'll start talking about those a little bit. Well, funding for foreclosure. So we've talked about funding for the foreclosure is started through an appropriation under general laws chapter 40 section 5, and a request to the assessors for funding there. So we'll talk about under 25 under, let's see, let's move on to the next slide, please. Oh, and I'm sorry, I'll go back to one slide, please. Back to slide 24, please. Yep, okay. And under chapter 65B, annual and budget shall include the amount estimated by the treasurer as necessary for land court proceedings for tax title foreclosures. So, all right, let's start with the two processes I mentioned, land court, and then we'll move on to the next slide, please. And under tax title, the rate of interest under chapter 60, section 62, prior to foreclosure, the treasurer, if treasurer receives payment on tax title and interest at 16% to allow the treasurer to redeem the property, the treasurer is formally required to accept no less than 25% of the original taking or sale amount, together with full amount of interest and taxes. Upon accepting payment, the treasurer may extend the time during which foreclosure proceedings may not be instituted for a period not exceeding 2 years. And an extension may be granted as well. The treasurer may redeem for the full amount specified minus any, any water, sewer, municipal light rates, charges, or interest for which there has been a substantial or misleading error or irregularity. So the instrument of redemption is filed upon the payment by a taxpayer, and like I said, extensions can be granted. Let's move on. Collectors. Let's see. So under General Laws, Chapter 60, Section 15, it contains a list of fees for written demands and other charges that collectors can charge. And there's a provision for waiver of interest charges that says the collector cannot waive fees, charges, or interest in excess of $15. That's not a lot amount. That's not a big amount. The amount has not been changed. But under for treasurers, the under 6262A authorizes municipal collectors and treasurers to make bulk assessments of their delinquent property tax to third. I'm sorry. They may auction off their tax title properties to a third party, and the statute allows cities and towns 66 allows city and towns treasurers to enter into payment agreements with persons entitled to redeem the tax title parcels, and these agreements could authorize waivers of up to 50% of the interest accrued. So that's a lot different from the chapter 6015 limitation of $15. And we have an IGR 2005-2008, which describes the process of sales of tax receivables. So move on to the next slide, please. Talked before the two processes, land court procedure and land at low value procedure. So we'll start talking about this situation. So land court, procedure, the takings, are initiated by the treasurer. The land court for tax title foreclosures. The land court has title examiners, and they will review every detail of every tax owner of the taxable parties, make sure that the proper parties were assessed and taxed. And the land court will provide notice of certified mail of all interested parties. So example given that, let's see, large property can't find the record trail went sour, couldn't find a probate record that was probated in another county. So nobody really knows who the assessors are. The land court examiner will, find the heirs of people who died and send notice them of all interested parties. And parties, once notified, they can redeem taxes. And then there's the publication of notice to foreclose petition. In that sense, it's a city can file a foreclosure, a motion to foreclose the right of redemption. So taxpayer, such a foreclosure petition basically says that the town and city has used all efforts to find the proper parties, and they want to file a motion with the land court to foreclose or prevent anyone with an interest from redeeming the tax title parcel. So even then, once the land court grants that motion to foreclose the right of redemption, a taxpayer or interested party still has 1 year in which to redeem or to pay for the outstanding taxes. Then under the Town of Andover versus State Financial Services case, where an owner through no fault of its own did not receive the town's petition to foreclose the right of redemption. Some very good reason. The due process rights of the landowner required the court to vacate the foreclosure decree. So, but complicated process. That's why you have tax sale attorneys doing a lot of this. I've handled a few of my own. They are pretty complicated. Well, let's talk about the next process. We are more familiar with that at Division of Local Services because we attorneys handle land low value for foreclosure situations. So it's a non-judicial procedure handled by us at DLS, the attorneys. In that case, there are fewer procedures for land under the threshold value of determined low value. So, and let's see, the treasurer may apply to the commissioner for an affidavit to allow foreclosing the tax title of land of not more than, well, 15,000 at the time of the statute plus CPI indexing. So basically say up to 23,000. If the land is valued over the threshold amount, it has to go to the land court process. But if it is in the 23,000 category or less, the land low value procedure can go forward. And once the attorneys review the land low value petition, the Commissioner of Revenue authorizes an affidavit, which can be filed with the Registry of Deeds, and a public auction can be held in that case. So on a case of Napier versus Springfield, it was held that the land low value process was reasonable and not a deprivation of one's property rights. So under the guarantee mortgage case, mortgagee of land low value property sued the town because the mortgage holder did not receive notice. But court held under General Laws Chapter 60, Section 79, mortgagees are not entitled to notice of their of right to redeem. So process is solely governed by Chapter 60, Section 79. Court upheld the land low value process, and the bank, despite paying mortgage on the property, was not entitled to redeem and had missed that right of redemption time period. Let's move on. So tax possession of property, as we're winding down here. So under tax possession property, custodian of tax title property may be managed by a custodian appointed by the Select Board or the mayor, and properties can be sold by auction. Alternatively, the public bidding statute, the Chapter 30B, the Uniform Procurement Act, bids could be taken and run through your chief procurement officer of your city or town. Next, please. So under General Laws Chapter 41, Section 39A, assistant treasurer, subject to appointment with the approval of the mayor or select board. The assistant treasurer is also sworn to perform faithfully and must post the bond annually in the form approved in the amount by the Commissioner of Revenue. The assistant acts as treasurer in the absence of the treasurer unless a temporary treasurer has been appointed. Then we have the temporary treasurer. Next slide. Under Chapter 41, Section 40, the select board may appoint a temporary treasurer to exercise all powers and duties of the treasurer until an election or appointment is made, and that person must be bonded as well. And same equivalent, Chapter 41, Section 61A, the mayor or city manager, without confirmation by city council, may appoint a temporary treasurer no longer than 60 days. But both provisions inform us that municipal finance laws allow for continuity of the town's finance operations. So with that situation of the cities being made, mayors being allowed to appoint without city council approval, it just shows that, the importance of your office making sure the towns and cities go on here. So, all right, let's talk about set off. We've heard before about collecting taxes through, the lien process, through tax title foreclosure. What if a person owing money did not own any property? So we look for other statutory remedies under Chapter 60, Section 93. One is set off. So in a set off, you've got if town owes taxpayer money for some purpose, wages even, the treasurer can set off the amount owed to the taxpayer, set off or take away the amount owed to the city or town from the wages there. And the no statute of limitations, whereas suing the taxpayer for collection of taxes can only be made in court no later than 6 years. So under a set off, there's no statute of limitations. Next, please. So got interest on refunds that must be paid after an abatement and exemption. Interest rate is paid at 8%, and the interest comes from the overlay account. And we'll talk about the municipal lien certificate. Under Chapter 60, Section 23, the collector shall furnish a municipal lien certificate upon written application within 10 days of the request. So Treasurer's Office looks at all charges, taxes owed, and they issue a municipal lien certificate showing that all the matters have been paid. That must be filed within 120 days or 150 days. Upon recording, the town or city loses its lien. So if a mistake was made saying taxpayer didn't owe anything, turns out they did, then the city loses the lien, but they can go off for other remedies under Chapter 60, Section 93. Moving down, next slide, please. The statement to continue a lien. So in that circumstance, the collector records a statement at the Registry of Deeds by providing a copy of the town accountant. So a collector may record a statement to continue a lien where the collector cannot perfect the lien by taking because of bankruptcy or they're bidding. So one last slide, let's talk about that. Another collection remedy, General Laws, Chapter 40, Section 57. It's a statute that allows for, as a non-property collection method, say a property owner owes money for taxes or other party owes money, then if they have a license, liquor license, health permit licenses, then that license that's held by the person owing money can be denied or suspended or revocation until payment is made. And a bylaw or ordinance must be enacted to allow for process there. So with that, I see I'm right at the edge of my time. So I thank you for your attention and I wish you all the best of luck.
Amazing job. He did it in 1 minute. He has I didn't see anything in chat. So thank you so much. Really appreciate it. And we actually have some right off the bat, with Sonia Hodge. She's going to be talking about tax title forms and procedures. Sonia, are you there?
Thank
You can unmute yourself. Thank you
Yep,
very much.
I'm here.
Okay, I'm going to find you and I'm going to pin you so you can be seen by everyone. Sonia, where are you? I'm just looking. What's your email?
I'm here.
No, what's your email? Because I have to find you on the
Oh,
list.
it's S Hodge.
Oh, okay, that's. No. Okay, I'm gonna get your slides. I'll be right back. Okay.
All right. Am I ready to go? All right. Good morning, everybody. My name is Sonia Hodge. I am the Treasurer Collector and Finance Director for the Town of Abington. I'm going to talk to you today about tax title forms and procedures. And I'm going to, if you can go to the next slide, Beth, I'll focus the information based on your role as treasurer staff. So I won't get too much into the weeds. My goal is really that you would be able to help your taxpayers with their questions and reassure them because tax title can be a pretty worrying situation to find yourself in. So hopefully this information will help you feel more confident in the information that you give them. Next slide, please. So what I'll do is I will go through this by looking at frequently asked questions that you've probably heard at your counter. I'm going to start with a little bit about the tax taking process, because even if you're just in a dedicated treasurer's office, what the collectors are doing really does impact you, and it's helpful to know what the full process looks like, again, so that you can answer questions for your taxpayers. So next, please. All right, so I think probably most of you have gotten this question. They've gotten a notice from the collector or from you saying that they're going into tax title, they're doing a tax taking. What does that mean? And it can be really worrying or scary the first time you hear the word tax taking. So this is a great opportunity for you to be able to reassure them that this is not foreclosure. Yes, it is the first step towards foreclosure, but foreclosure is not happening right now. There's still plenty of time to make payments, plenty of time to redeem the property. They still live there. They do have the option of selling the property if that's what they want to do. And selling would mean they get to keep their equity. So there's lots of options to explore and time to explore them. And this is also a good opportunity to suggest that they speak directly with the treasurer so that they can figure out exactly what the timeline is going to look like and figure out where to go from here. So the tax taking is just perfecting the lien and getting it filed at the Registry of Deeds. All right, next slide, please. So the timeline for the taking itself is after the taxes are due, after that second half or fourth quarter, you're going to send a demand. 14 days later, you can advertise in the newspaper all of the delinquent properties. And then 14 days after that, you can actually do the taking and prepare your instruments of taking. This is the minimum requirement here. It's recommended that you send at least one more notice before you advertise in the newspaper. I do too. I also do a notice before I send my demands for anybody who has a really small balance. That way they can get it cleared up before there's another fee on there. But every office is going to do it differently. So I do recommend though sending at least one more notice. After the taking, the interest rate goes up to 16%. So it's already at 14%, then it goes up to 16. All right, if you go to the next slide, this is an example of an additional notice that I send. I'm not going to read it, but it's an example of something you can send to let them know what's happening and what's coming up next. All right, next slide. So here's a fiscal year 21 real estate tax account that has gone into tax title. And you can see that after the 4 quarters were billed, a demand was sent. Then you can see that collector's fees were posted. And then at the very bottom, you can see that the taxes were transferred to tax title. And if you look at the amounts there, you can see that the total unpaid tax was $6,400. There were fees of $141 and interest of $409. And combined, that brings the total amount sent to tax title to $7,018.20. And then if you go to the next slide, This is the new tax title account. And you can see that $7,018.20 is the new principal. That's what your 16% interest is going to be calculated on. So it's not uncommon for someone who's newly in tax title to say, wait a second, my tax bill was only $6,000, but you're saying there's $6,700 in my tax title account. You're overcharging me. This is a way that you can explain that no, everything gets rolled in together on the date of the taking, and that's the new principal. All right. Not as common, but very important to keep in mind. Bankruptcy requires that all collections activities be halted for any bills that were unpaid or delinquent as of the date they filed their case. So in a case of a real estate account, if they're past due and they file for bankruptcy, you cannot send your demand. You cannot put them in tax title. You can't even send them notices. Just put a hold on the account. Once the case is resolved and dismissed, then you can resume those activities. Now, another thing to keep in mind, though, is that new bills are required to be paid on time, and you can do collections activities for those bills. But when you're talking about real estate with a tax taking, you can't do a tax taking for fiscal year 22 when fiscal year 21 is being held for bankruptcy. So you just wait for all of it. Once the case is dismissed, then you can start this process back up and get your lien filed. All right. Now, once you've gone through the taking process, the tax title lien will be filed at the Registry of Deeds in your county within 60 days. The taking is going to need to require or include specific information that identifies who the assessed owner is and which parcel is being taken for non-payment of taxes. If you are missing some of that information, then you get into a situation where the tax title will need to be disclaimed, possibly reassessed if the assessment itself was incorrect, and that requires a whole lot of work between the collector and the assessor. So very important that when the collector is preparing the tax takings, that all of the information in the advertisements and notices are proper. All right, so if we can go to the next one. This is form 346. This form is going to be completed by the collector and submitted to the treasurer with a copy going to the accounting office, indicating all of the parcels that were taken and that the treasurer needs to set up new tax title accounts for. Now, in a town where you have a collector and a treasurer who are the same person, they'll be submitting this to themselves with a copy to accounting. The next slide shows the instrument of taking. And this is what actually gets filed at the registry. The collector should also provide a copy of this to the treasurer once the taking is completed. Don't wait for the original copies to come back from the registry. Just make a copy and make sure that the treasurer has this. But this has all the information identifying the parcel and the assessed owner and the amount of taxes. And again, you can see in the middle there are 7,000 number that we saw in previous statements. So it should all tie together. All right, now form 410. This is the tax title account information. So this will be created by the treasurer from all the information that they received from the collector. Now this is a system generated version. There is an old school paper form that has all of the same information on it. As long as you have the information, it doesn't matter what the form looks like. So this will tell you when the demand was sent, how much it was for, where and when it was advertised, and where and when it was taken, the reference for the Registry of Deeds, the book and page, or document and certificate number if it's lay in court. So once you have all of that information, you'll want to set up your tax title files. I do a separate file for each parcel, and I alphabetize it by assessed owner. You could also do it by your parcel ID or your parcel address, whatever makes the most sense. We had some old records that were by parcel ID, and then the assessors redid their maps and all the parcel IDs changed. So keep that in mind. If your assessors make some changes, it might impact how your filing system works. So that's why I do it by assessed owner. Now, this is a notice that would get sent out to the taxpayer after the tax taking has occurred. You are required to notify them once they go into tax title. So this is just an example of what I do. Now, I also send a sample payment agreement so that they can take a look at what a payment plan might look like. And we'll talk more about payment plans shortly, but I find it's helpful to go ahead and get that conversation started right away. Now, one other thing that you'll want to do, which we'll talk on this slide, is once they go into tax title, you want to post the preparing and recording fee for the certificate of redemption. And that's so that when they need their payoff amount, if they're going to redeem the property, they are paying that as well. And that way your treasurer's office can go ahead and file that release for them. It's not required. You could instead send the certificate of redemption to the homeowner and then they can file it. But we no longer do that in our office because we found a lot of folks weren't actually filing them. And then years later, we're having an attorney request a new release. So this way it gets it taken care of. Now, in order to get that release, they need to pay the amount in full. They can pay it in one payment. They can pay it in many partial payments. It's really up to them and the treasurer how they want that to go. All right, next slide. This is an example of a partial payment. The partial payment is going to be applied first to the interest, then liens, fees, and tax. Although our system here is going to post it to interest, liens, tax, and then fees. And that's really partially, I think, because fees do not have interest accrued on them. And when we talk a little bit later about legal fees, those may or may not be granted by land court. And so it makes sense to have the fees be the last thing to get paid. Now, regardless, nothing gets redeemed and the release is filed until the account is paid in full. Okay, next. And this is an actual copy of a certificate of redemption. And you'll notice it looks quite a bit like the instrument of taking, and it has a lot of the same information to make sure that the right taking is being released. And again, this really should be filed by the treasurer's office just to be safe. Okay, so now that someone is in tax title, if they're not making payments on their current tax year, every quarter or twice a year, taxes are being billed. If those are not being paid as well, then at the end of the fiscal year, they're going to have unpaid amounts that need to be certified to their tax title account. And this should be done by September 1st. You don't have to send a demand before you do this, and you don't have to send a notice when you do this, although a notice probably is a good idea. There's also no additional forms that need to be filed at the registry when you certify subsequent taxes. It's just an internal process that the taxes come off of the current year account and get moved over to the tax title account. Now, on the next slide, we have Form 347, and this is exactly like Form 346, except this is for subsequent taxes, not initial takings. So again, same information, basically. This allows the treasurer to add these amounts to the existing tax title account. The next slide has an actual tax title account that has subsequent certifications. So you can see that there's an initial transfer for 2019 taxes, and then a subsequent certification for 2020 and 2021. And you can see they were done before September 1st. The 16% interest, go back really quick. The 16% interest on those subsequent taxes starts as of the date that you do the certification. I didn't include a sample of a notice that can be sent out, but it would be similar to your tax taking notice after they first go into tax title. Okay, now we can go forward. Once someone has been in tax title for 6 months, the treasurer is able to file a foreclosure case in land court. If the taxpayer is making partial payments, you can extend that another 2 years so that it's 2.5 years after the taking. But there's really no penalty for waiting longer other than you have unpaid taxes for longer. So a lot of treasurers will give more time than that. But again, every treasurer's office will do this a little bit differently. It's really, there's no right way, but that's the law says you have to wait at least 6 months or 2.5 if you've given an extra 2 years in writing. Now, if there are abandoned properties on the parcel, you can file sooner. If the assessed value is less than the amount on the tax title account, you can file sooner. Or if the parcel qualifies for land of low value, you can file sooner. And we will talk about land of low value, but not the other two options because they're not nearly as common. And once a foreclosure case has begun, it usually takes 1 to 2 years to finish. So even if a case has been filed, the taxpayer still has time. They can still be making partial payments. They can still be working on a payment plan. It's good practice that if you get a payment plan, you're going to hold your foreclosure case, make sure that they're sticking with it. And then at that point, if they don't, you can restart the case again without having to refile anything. So not a bad idea to start the cases. You can put them on hold, but it is a lot of stress on a homeowner, so it's not something you want to just do lightly. All right, next page. This is the first part of the tax lien complaint that you would file at land court. And nowadays, your attorneys are going to be filing this for you. Once you get to this point, the land court filing fee can be added to the tax title account, and then any future legal bills can also be posted to the tax title account. Again, interest does not accrue on the fees. Land court would be the final say on whether or not the taxpayer needs to pay those legal fees. So what they would want to do is go to land court, request a payoff amount, and then your town attorney would be able to provide information about the total amount due plus legal fees that have been incurred or will be incurred as a result of having it paid off. Your land court judge will decide what they pay on that. Now, in practice, how we do it in my office is all of these legal fees get posted to the account. And then if they want to come into my office and pay off with me directly without having to go to court, then they can pay everything that's due. I usually give the attorney a call to see if there are any unbilled charges, get those included in their payoff amount, and then they can just be done with it. They don't have to worry about any additional fees. They don't have to worry about going into Boston or going before a judge to request anything. So it ends up saving them time, but it's really up to the taxpayer at that point how they want to handle it. If they just want to pay it and get it over with, or if they want to go to court and see if they can get some of those legal fees removed. All right. Now, we had talked about they have 6 months or maybe 2.5 years to pay off the tax title before they go into foreclosure. Sometimes that's not always doable. So they'll ask if we have payment plan options. And in our town, we do. We have accepted Chapter 60, Section 62A that allows for a 5-year payment plan. Now, this payment plan requires at least 25% down, but it does allow for up to 50% of interest to be waived. Now, that's not 50% of the interest that they'll pay over the life of the tax title. That would be quite a bit of money. It's 50% of the interest that's accrued as of the day they signed their agreement. So when they come into your office on March 1st and there's $3,000 of interest due on that day and they sign an agreement, it's going to be 50% of that $3,000. This would have to be accepted by your legislative body. So town meeting, city council, and the vote would need to specify the terms that become your bylaw. Another important part of this is that the future bills need to be paid on time. And in our office, we include water and sewer bills as well. So if they're not making future tax payments on time, they're not, they're getting water and sewer liens added to their tax bills in future years, then they're not complying with the terms of the agreement, and then they would not qualify for that interest waiver. If we go to the next slide, I've included a sample payment plan agreement so you can see what I use. Now, this corresponds directly with the bylaw that we had passed at town meeting, but it has all of the terms outlined in it. You can go to the next page. We do a 5-year plan with a 25% down, and we did a 25% interest waiver. Now, I've actually had the question asked, why in the world would you waive any interest? You want to collect as much as possible. But I have found that having a payment plan with a little bit of a carrot at the end brings in a lot more money in the long term than if we were saying, no, you got to pay all that interest. This formal agreement really gives them kind of a light at the end of the tunnel. When someone signs an agreement in my office, you can literally see the stress start to come off of them a little bit because they have a way out now. So giving them 25% off of whatever's due that day at the end of the agreement, to me, is nothing compared to getting the balance paid, getting them back on the tax rolls, and allowing them to sleep again at night. But again, every treasurer will do this differently. Now, the next page is the last page of my agreement, and you can see all of this will have all of the terms for this individual parcel, the amount that's due when they're signing, the 25% down payment that they're required to do, what their monthly payment will be for the next 60 months, and then how much of an interest waiver they would be eligible for if they meet all of the terms in the agreement over those 5 years. Now, one thing to note is if they pay it off early, they still get that interest waiver. They don't have to stick to 60 months. So I've had people come in and say, all right, I want to fill out this agreement, but I might pay it off in a year instead. Will I still get it? Absolutely. Let's get it paid off. They can say, you know what, I'm going to pay it off anyway in a year. Can I do this agreement so I get an interest waiver? Sounds good to me. As long as we're getting it paid off and they know that they have something to look forward to, that it's going to be done, and they get this little bit of a benefit, then I think that's great. Okay. Now, more than half of the people I talk to about this, they say, wait a second, 25% down is not doable. My balance is $30,000. I cannot afford 25% down. And that is going to be prohibitive for a lot of people. So what you can do is you can revert back to that 2-year requirement that it needs to be paid off by then before a foreclosure case is filed. But what I do is I stick with the 5-year plan. I forego the 25% down payment, but I also don't allow the interest waiver, because if they're not following all of the terms of the bylaw, then they really don't qualify for that interest waiver. I find, though, it's still a formal agreement. It's still a long enough term with small enough payments that most people can stick to it. And so again, it gives them that light at the end of the tunnel, and they're more likely to stick with it. Now, I require that all those future bills be paid on time, just like the event, in order to forego or at least forestall a foreclosure case. But instead of 60 monthly payments and 25% down, we just do 61 monthly payments. So if you go to the next page, this is a sample of the terms of an agreement that did not do 25% down. You can see the down payment is the same as their 60 monthly payments, and I crossed out that there would be no interest waiver. So it's clear when they're looking at it that they're not getting that interest waiver. Okay. This is a question I get a lot. Sometimes it's from the adult children, sometimes it's from the taxpayers themselves, that they're elderly and they're on a fixed income and they can't afford it. What can we do? Well, the first thing really is to send them to your assessor's office. The assessors can talk about deferrals. They can talk about other exemptions that they may qualify for. And the assessors really are the ones that are going to process all of those. So they need to have those conversations. Doesn't mean you can't provide them with information. A deferral allows someone to move their taxes into an account that is a lot like a tax title account, but it's not considered past due. The interest rate is 8% instead of 16%, but there are income limits. So if they make more than $20,000, then they're not eligible. Once the person that's in deferral passes away or they sell the property, then your 6-month clock for foreclosure starts to tick. You don't have to foreclose in 6 months, but that's when you'd be eligible to. I do recommend that for anyone in deferral that you send statements at least annually. You're not required to have an adult child be aware of the deferral or have them sign off on it. And it can be an emotional time if someone in deferral passes away and their children find out that there's a $50,000 lien basically on their account because their parent decided to defer the taxes. Many of you have probably seen stories in the newspaper about it. There's really no way around that. I mean, these are adults, they can make their own decisions. But if you're sending statements, if children are helping them at home, it gives more opportunity for them to see that there might be some taxes that are being deferred so that they can ask questions beforehand. You know, some taxpayers just don't want their children to know that they're doing this, and that's okay, that's their right. But it does make our jobs a little difficult when they find out about it down the road. So do what you can, make sure that your taxpayers at least are aware of the balances that they're accruing. And really that's all you can do. But again, send them to the assessors. You might also have other agencies or departments in your town or city that can provide some resources to your taxpayers who can't afford their taxes, because sometimes selling the property isn't a very good option. So it's a great time to do what you can for people, try to work with them and see what you can do to help them out. You know, we can't just say, don't worry about it, don't pay your taxes, because we are hired to do our jobs. But there are some resources out there that we can offer. Now, this is an example of a tax deferral account, and you can see that every year they've applied for it and every year they've been granted it. You can see also in 2019 that there was a tax title certification. Now, when I say that this is an account that is a lot like tax title, it's for a reason. If there are unpaid taxes that were not deferred in a year, so this likely was a CPA tax, because CPA cannot be deferred, or maybe a sewer lien. If it remains unpaid, it gets certified to the same account, but it's considered a tax title, and the interest rate is 16% on that amount. I'm not going to foreclose on this because there's an active deferral already, but it does give you an avenue of moving these taxes over without having to go through a tax taking. You don't have to file anything at the registry either when you do this. All right. Now, over on the left where it says IGR 08208, that is a link. You can click on that if you pull up the actual PowerPoint. And you can print this out and review it if you'd like. It's quite long, but it's there if you want to learn more about the deferral process, the program, and what you need to do for that. Now, the next slide. Excuse me. I think we need to go back to the PowerPoint. So the next slide, when we get there, has another link. I think you're in internet, you're in your Chrome right now. You need to go back to the PowerPoint, I think, Beth. So just down at the bottom, if you bring your PowerPoint program back up. Okay, so now if we go to the next slide, here's another guide that you can give to your taxpayers. This is shorter, a little more easy to understand. It's not super easy to understand, but it's helpful at least. Excuse me. Again, there's a link there that you can click on to pull this up. Okay, moving on. Now, if a property is in foreclosure, oh, go back one. If land court issues judgment in favor of the city or the town, the municipality is now the owner of the property. The previous owner does have a year if they want to come back to the court and request that they be allowed to pay off the taxes and own their property again, they redeem it, they can do so. So they only have a year though. After that year, the municipality doesn't have to worry about that decree being vacated. At that point, the municipality can choose to either keep or sell, auction the property. And it's important to note that the previous owner is not going to get a refund of proceeds from that auction that are above their tax debt. The town keeps everything. So this is a reason why, you know, when I'm working with taxpayers who are in tax title, who are getting close to a foreclosure, you know, the balances are creeping up, they haven't been making payments. I recommend that they seriously consider selling the property. They really can't afford to pay the taxes on it going forward. That's really going to be their best option, because then they get to keep their equity. You know, when they sell the property, they pay off the taxes and they keep what's left. If we foreclose, we keep it all. They don't get anything. So it's important to notify them of that beforehand so that they're not surprised, because, you know, this is not a mortgage foreclosure. This is very different. And we don't want them to be surprised by that. So I counsel people all the time, if selling the property is an option, you want to consider it. Talk to a real estate agent, see what your options are, because once you go into foreclosure land, it can be sticky. Now, if you foreclose on a property and someone is living in the home, they don't just leave. You have to follow some pretty strict eviction requirements, and your tax title attorney will be able to help you with that. That's not something you'd want to tackle on your own. But another reason to try to avoid foreclosure at all costs, try to get people on payment plans. You know, if they can't pay, try to, you know, work with them to help them get the property on the market, because that really is going to help you out. I mean, foreclosures are time intensive and they cost money. So it's not something that you want to just run into without thinking about it. Now I have a tax lien sale information here. I'm not going to really go into it. We don't do these here in Abington, but it is an option for a town. It's especially an option if you need to really get some tax revenue in. If you have a lot of delinquencies, a lot of people in tax title, this is an option. It's not something that I really feel comfortable with, but it's in statute that it is an allowable thing to do. And so I've got the reference there if you want to look up section 52 to find out more information about tax liens. But that really is its own class. So I'm not going to go into that one. Now, land of low value. For a piece of land that is valued below the DOR's threshold, which they change annually, you can file with DOR directly for foreclosure, and they'll issue an affidavit that would be filed at the Registry of Deeds. This is a much quicker, much cheaper way of foreclosing on land than going through land court through a traditional foreclosure. Now, there are some differences though. Once you file that affidavit, the foreclosure is not complete until you do an auction. So you hold the auction. If there are no sufficient bids for a parcel, then you have to adjourn and do a second auction at another date for that parcel again. If you still don't have any sufficient bids for that parcel, now the municipality owns the property and the foreclosure is complete. If you have a piece of land that the town or city really wants to keep, they don't want to risk someone purchasing it at auction, then your really only good option would be to go to land court and do a traditional foreclosure. It costs more money to do it that way, but if it's a particular piece of land that you really want to hang on to for whatever reason, that's the way you'd want to go. Now, for a land of low value auction, this is slightly different from a traditional foreclosure because you do need to hang on to any proceeds that are over and above the tax debt, and the taxpayer has 5 years to request it. You don't automatically send it out. They do have to come to you to ask for it. But after that 5 years, the money reverts to the treasury, and the previous owner has no right of redemption beyond that time period. And lots of notices have to go out before a land of low value auction. So assuming these are not, 100-year-old tax takings, you should be able to get a hold of them and notify them of what's happening. All right. And this is, I think, the hardest question to answer. Why not give people more time and allow them to stay in their homes? And this is particular, I get this mostly with elderly taxpayers. You know, my parent or this person is getting up there. Why are we trying to foreclose on them? Let's just let them stay in their home. And it's a very valid question and one that is really difficult to answer. You know, if you give people all the time in the world, you're not collecting the taxes that you were hired to collect. You're not having that revenue come in to pay for town services. You're allowing balances to balloon to a point where the taxpayer could not possibly pay them off. They can never get ahead if it gets too high. Whereas if you're foreclosing right away, you're causing a lot of extra stress for the homeowner. I mean, they know they're behind. If they're getting slammed with notices after notices and they find out that they're now in foreclosure, they're about to lose their home because they've been behind for, you know, a year and a half, that can be a lot on a homeowner. It's also expensive to foreclose right away, and it's a lot of extra work for a treasurer to handle all of these. So, you know, I kind of look at it and think somewhere in the middle is probably the way to go. You know, at the bottom, you know, at the end of the day, this is what I was hired to do. I'm hired to collect the funds. I'm hired to manage the funds of the town. So I do have to go down this route sometimes, but I try to avoid the foreclosure as much as I can. But a lot of times there does come a point where foreclosure is really the only option. And again, trying to convince people that, you know, if you can sell the property, that's really the best way to do it, because I don't want to be a landlord. I don't want to have to do an auction. And then they get to keep their money from the sale. So again, this isn't the emotionally challenging part of the job, is trying to decide when to foreclose and which properties to foreclose. It's not easy, definitely not easy. All right, now I got through that a lot faster than I intended. I think I probably was talking really fast. So hopefully some people have some questions that we can answer. Yeah, I didn't read everything on the screen. So, you know, the actual tax taking process, there's a little bit more to it that is on the slides that I didn't really discuss. But does anyone have any questions? If you do, throw them in the chat or unmute, and I'd be happy to answer. But I appreciate you having me on. I enjoyed getting everything prepared for you. And I know that the PowerPoint is on the website. So pull that down, print it out, review it. And if you do have any questions, you can reach out to me. Beth could always provide you with my email address if you need it, or if you're on the listserv, you can ask questions there. But ultimately, really, every town, again, does it differently. So you can talk to your treasurer and see how they handle things and what is their method for handling tax titles and when do they go into foreclosure. Okay.
I'm gonna ask, where can we print it out? And I have on the chat the website, but I will type it again. And the question was, how do you protect yourself from personal liability?
Personal liability in terms of what? Give me more information.
Kay Hartwell, can you unmute yourself or write more in the chat?
Oh, okay. So from errors or other mistakes in process. Well, you wouldn't be personally held liable for something like that. Now, if there was a an assessment error or the wrong information was on the taking. So maybe it was assessed properly, the taxes went out right, but the actual taking had some incorrect information, then it would need to be disclaimed. Everything would come, it basically would go away. The taxes would maybe need to be reassessed if the assessment was incorrect, or you just do a new taking with the correct information if the assessment was correct. But the treasurer is not held personally liable for any of those errors. In the foreclosure process itself at land court, they assign their own title examiner to review the deeds and any liens that have been posted to that property through the registry of deeds to make sure that everything is kosher. And land court is not going to issue judgment without having gone through all of those steps and made sure that this is a valid taking and that the foreclosure can move forward. So again, you're not personally held liable. The treasurer does need to have a bond for, you know, the management of funds. But in terms of tax title, that really wouldn't come into play that I know of.
We have another question. Do you track payment? Do you want to read that one, Kevin?
No, I don't. What is it?
Do you track payment plans yourself, or do you have send reminders if no payment received as agreed? Are payment plans signed by you and the taxpayer?
Yes, yes, and yes. I have a spreadsheet where I track every payment plan that I have. I have, you know, the taxpayer, that is doing the payment plan, the address, the parcel ID, what the balance was when they signed, what the interest was when they signed, what their potential interest waiver is if they finish the payment plan, and then I enter the date that they make each month's payment. So I have every column has, you know, April 2021, May 2021, June 2021, and I check off to make sure that they've actually made those payments within that month. So I require that, you know, February's payment be received sometime in February, March's payment be received sometime in March. And assuming that's the case, I consider them on time. And then occasionally, you know, quarterly, maybe I'll check in with the water and sewer departments to see if my payment plan accounts have any past due balances. And then I would say every quarter, I would send reminders to my payment plan folks if they have fallen behind. And I have a series of letters that I send that get a little more formal if I'm having to send lots of reminders to them that you were getting to, you know, after so many notices, we're getting to a point where you're not in compliance and we need to maybe meet again and talk about the payment plan, or we're going to be soon talking about foreclosure instead.
So we have a question. How long does it take to get bonded?
Your bonding is required for a treasurer and an assistant treasurer. So that is going to happen probably with your town manager's office. Whoever handles the liability insurance for your town, they will provide you with the forms to sign to be bonded. And then it doesn't take very long. It's effective your first day of work. So if you're a treasurer or an assistant treasurer and you're not bonded, you need to talk to your town manager's office and make sure that you get bonded right away.
A kind of related question, what is a typical bond amount for a treasurer?
Well, it depends. It's going to vary based on the amount of cash that you handle in your town. And do we have a session coming up, Beth, about cash
Yes,
today?
right after this, yeah.
So I would save your bonding questions for that presentation because they're going to be talking about that, I guaranteed. So I don't have that information in front of me right now, but there's a chart that the state provides based on the amount of money that you are handling, how much your bond needs to be. And the assistant treasurer, I believe their bond is 25% of what the treasurer's bond is. So again, I would ask at the cash presentation those bonding questions. You'll get a better answer.
Great. That's like a preview of coming attractions. The last question I see is, how many payment plans do you have?
You know, I don't know offhand exactly how many, but I have probably close to 2 dozen. And some are in varying stages of compliance. But it's not something, you know, if you're 3 days late on a payment, oh, you're out of compliance, I'm going to file foreclosure now. I really do try to work with people as much as possible because, like I said, I don't want to foreclose. I don't want to be a landlord. I'd much rather do the work of tracking their payment plan and sending notices and getting them caught up than going down that road of you know, a foreclosure and a potential auction or eviction if it's a home, which a lot of my payment plans are owner occupied homes. So it's worth it.
You have a question about, you mentioned only that you only offer 25% interest waiver. So if a town adopts a chapter 60, section 62A, is there a minimum tax waiver?
No, there's not. The statute says that the payment plan can allow for up to 50% interest waiver. So it could be 0 if your town wanted to do that. In my opinion, there's not much point to that. I think that having a little bit of an interest waiver shows some good faith on the town side to get people caught up, but it's certainly an option and it would be allowable. But any of those types of votes, if you wanted to vote that section in, it would be reviewed by your town council. So they'd be able to identify if there were any errors in it.
And someone has, how do you calculate their monthly payments?
Oh, that's a good question. I don't have a great answer for that other than I created a spreadsheet to calculate it for me. I can send a blank one out to Beth and she can send it out to the participants if that's okay, Beth.
Mhm.
And it's, I actually print a copy for the taxpayer when they sign their agreement so that they have something, you know, at home they can check off, paid that month, and they can kind of keep track of where they're at. But it's just a calculation in Excel that I did. And I've done it also in our software system and they come up with different numbers. So I hope it's right that what I'm using, but the logic makes sense to me. So I think it's roughly correct. It's close enough over a 5-year payment plan. But yeah, I'll send that to Beth.
So someone asked if you can type in the chat your email address, so that
Yeah.
way people have it.
Yeah, let me do that right now.
And the other thing is, I must have done a typo because I couldn't cut and paste because I was sharing my screen. So I'm gonna share my screen so everyone sees the where the handouts are. So it may take a couple seconds. Okay, now I'm gonna do it again. Now that I found it. So on the screen, there's handouts, it's on the education programs. And I have a whole new one for staff school handouts for 2022. And it has all the 3 dates and they're all live links. And I also have YouTube videos of all of the different sessions. The first session for the collectors, it's all in one recording. Last one for the advanced, it's separate ones. And today will probably be 2 separate ones or 2 or 3. So these are really helpful. All of the things that they talked about this morning is on is there, and also Sonia's right here.
That's awesome, Beth. Thank you for doing that.
So Sonia gave us her email. Are there any other questions? We have like a few more minutes. Otherwise, you have a little bit more break before the next thing. So it's fine. Sonia, I just have to say you did an amazing job. She had so many slides. I said, you just have to do a synopsis. And then the next thing she's like, I have too much time, but I think it's great to have extra time so you can really answer the questions. And they really had a lot of questions for you. So that's great.
Thanks again for having me, Beth. I really appreciate it. I had a good time doing it.
Great. You'll be tagged to do another one, I'm sure. Any more questions? Are we going to stop the recording otherwise? Okay.